Well, having practiced international humanitarian law, that's the part of international law protecting persons affected by armed conflicts, for 13 years with the International Committee of the Red Cross, and then having taught it to university students for 20 years, I thought it could be useful to provide an overview to both students and practitioners, focusing on certain things. First, the basics, to make sure that the basics are understood. Second, the controversies. Third, practical solutions which allow belligerents nevertheless to conduct their armed conflict. I have to explain here that it would obviously be desirable that no one conducts armed conflicts, but international humanitarian law applies to armed conflicts. And if it makes it impossible to belligerents to conduct armed conflicts, it will simply be ignored. Therefore, the solutions of humanitarian law to controversies and to practical problems arising can never be the humanitarian ideal, but must be a compromise which is nevertheless realistic. Furthermore, I wanted to combine, as we do here at the Geneva Academy of International Humanitarian Law and Human Rights, to combine different branches of international law, not simply to present humanitarian law, but to present it in relation to human rights law, international criminal law, general rules of public international law, and international migration law, because today a problem arising in an armed conflict can no longer be solved simply by looking at the rules of international humanitarian law, which in the Geneva Conventions of 1949, which is the main treaty base of humanitarian law, are also quite old. And in the meantime, international law has developed, and therefore the rules of the Geneva Conventions have to be interpreted in light of more recent instruments. And I wanted to put a special focus on implementation, because as the great Canadian human rights lawyer John Humphreys said, human rights without effective implementation are shadows without substance. And I think for humanitarian law, this is even more important, because unlike human rights, humanitarian law is not an ideal. Ideally, we would have no armed conflicts and therefore no need to apply humanitarian law. And therefore, if humanitarian law is not implemented, it is totally useless. Now, my interpretation in this book is obviously profoundly marked by my personal experience. On the one hand, my practical experience as a delegate of the International Committee of the Red Cross, although I must say that I do not always defend in the book the contemporary interpretation of rules made by the International Committee of the Red Cross. Today, it is also marked by my doctoral students, my former doctoral students, who have given me a lot of ideas, who have changed even my interpretation of the law through their theses, and some of them are today professors. And finally, it is also marked by the questions. LLM students, master students, and bachelor students have asked me those questions, both allowed to understand where are the possible misunderstandings in humanitarian law, but also often have suggested new solutions, and then I have to explain in my book either why this is a good idea or why this apparently good idea would have detrimental effects in actual armed conflicts. So, if you want to know what is in this book, I would say, after the usual introductions and so on, I first deal with the sources of humanitarian law, and there we have to admit that if you look for a solution as practitioners for a problem arising in an armed conflict, you do not only consult treaties. As for customary law, it is certainly important, but it depends very much of your concept of customary law, whether you find that a certain rule is customary or is not customary. Therefore, we have also to deal with other realities, with all kind of non-binding documents, guidelines, interpretive guidance, but also, for instance, with the commentaries to the Geneva Conventions and additional protocols produced by the International Committee of the Red Cross. So much for the sources. And then I try immediately to come to the respect of the law, because I think that, in particular, students, if you don't first explain them that this law is implemented, but is implemented in a different way than most domestic laws, even the nicest rules on the protection of the wounded will not really impress them. So, how is the law, how the respect of the law is ensured is, on the one hand, by the general mechanisms of international law, for instance, the role of the United Nations, of UN and regional human rights bodies, of state responsibility, of countermeasures, reprisals, and so on. But then we have obviously the specific mechanisms of international humanitarian law, like the obligation to train armed forces, the International Committee of the Red Cross, and individual criminal responsibility. Next comes the scope of application of the law. When does humanitarian law apply? And this is the first and perhaps the greatest difficulty of humanitarian law, that it only applies to armed conflicts. And therefore you first have to classify a situation as an armed conflict, and then to determine whether that armed conflict is an international armed conflict or a non-international armed conflict. And then obviously arises also the question, what kind of persons are protected by humanitarian law? Who is an addressee of humanitarian law? Believe me that I experience plenty of people who think only combatants have to comply with humanitarian law, while this is wrong. When does it start to apply? When does it stop to apply? To what kind of acts does it apply? And the next chapter is on international and non-international armed conflicts. Obviously today most armed conflicts are non-international armed conflicts, while most of the treaty law has been made for international armed conflicts. There is a strong tendency to make analogies from the more detailed rules applicable to international armed conflicts to non-international armed conflicts, but this can also have some downsides, and so it is important to discuss exactly to what extent can we apply the rules of international armed conflict, which are the most detailed rules explained in this book, also to non-international armed conflict. And then it's only then that I come to the protective regimes, which is what is normally taught: the protection of the wounded and sick, combatants and prisoners of war, civilians in the power of the enemy, humanitarian law of belligerent occupation, the missing and the dead, the protection of the civilian population against the effects of hostilities, means and methods of warfare, weapons, what weapons may be used in what conditions, and to specific parts on the law of naval warfare and the law of air warfare. And after having studied this, we can come to the relationship between humanitarian law and other branches. International human rights law, international criminal law, international migration law, the law of international peace and security, called by the specialists the jus ad bellum, and the law of neutrality. And finally, there is a chapter with sections on some cross-cutting issues which cannot be solved under the wounded and sick or the relation with human rights law, where everything comes together. And this is, for instance, the issue whether humanitarian law only prohibits and prescribes, or whether it is also a legal basis which authorizes certain action. Other issues are terrorism, drones, lethal autonomous weapons, arms transfers and international humanitarian law, cyber warfare, private military and security companies, gender and humanitarian law, the protection of cultural heritage, the protection of the environment, humanitarian assistance, non-state armed groups. That's a point which is particularly dear to my heart, because today half of the parties to armed conflicts are non-state armed groups, while the law is still relatively state-oriented. So we have to understand how this law works with non-state armed groups. And finally, two very practical issues: who may be targeted in a non-international armed conflict, and who may be detained on what basis and based on what procedures in a non-international armed conflict. Why do I focus only on non-international armed conflicts in those two issues? It is simply because the law of international armed conflict contains detailed rules which are discussed in the substantive chapter on the protective regimes on these issues, while it is very controversial, unclear, but essential for the protection of war victims to clarify how this works in non-international armed conflicts. And here it is also an issue of the relationship between international humanitarian law and international human rights law. So my hope is that this book will one day no longer be used because we have no more armed conflicts, but in the meantime that it gives some basic ideas, it avoids some basic misunderstandings, and at the same time gives some solutions on detailed issues. And here my aim is first to explain the controversy, and then nevertheless to give my opinion on it.